And for those of you who are maybe less familiar with Federalist Society, I thought I'd just kind of describe what it is, because there's definitely some misconceptions out there. But we are a group of law students and attorneys who are interested in the current state of the legal order. And we believe that the state exists to preserve freedom, that the separation of powers is central to the Constitution, and it is the role of the judiciary to say what the law is and not what it should be. And this year, it's my personal goal to invite more debates, more panel discussions, and just invite more dissent on campus. So with that said, before we jump into this event, a couple quick announcements regarding upcoming events. The first is that on September 18th, we're going to have an administrative law event here on campus. There will be Chick-fil-A served, and we are partnering with ACS. So that's a really great event to invite a friend, someone who maybe doesn't share the same perspective of the law. And that event is going to feature Jonathan Wolfson of the Cicero Institute. He was also in the Trump administration. And it will also feature SMU's own Professor Cortez, who is our admin law guru. We also hope that you'll join us the weekend of September 20th and 21st for Texas Chapters Conference. I know the price tag is steep, but there are opportunities to volunteer. So if that's something you're interested in, please talk to me, talk to MK, I think she's in this room. If not, I'm happy to answer any of your questions regarding that. And today, we are so excited to welcome back to campus our speakers, Stephen Hammer and Professor Josh Blackman. Both are esteemed experts in constitutional law. We're also incredibly pleased to welcome to campus Judge Reed O'Connor from the Northern District of Texas. Yes, John, alongside his clerks. So without further ado, we can jump into our event and I'll present our speakers and then pass the mics over to them. So we are so pleased to have Mr. Stephen Hammer back on campus. He is an associate at Gibson, Dunn & Crutcher. He is a member of the firm's appellate and constitutional law and administrative law and regulatory practice groups. Before joining Gibson Dunn, Mr. Hammer served as a law clerk to Chief Justice John Roberts of the Supreme Court. Sorry, there's a lot. Chief Justice.
I lose my voice with John Roberts all the time. He makes me just.
Judge Gregory G. Katsas of the U.S. Court of Appeals for the D.C. Circuit, and Judge Jeffrey Sutton of the Sixth Circuit. He graduated magna cum laude from Harvard Law School, where he served as managing editor of the Harvard Journal of Law and Public Policy. Before law school, Mr. Hammer served as an infantry officer in the 82nd Airborne Division of the United States Army. Mr. Hammer also maintains an active pro bono practice with a focus on religious liberty issues and crime victims' rights, and serves as vice president of the Dallas Lawyers chapter of the Federalist Society. Professor Josh Blackman is a national thought leader on constitutional law and the United States Supreme Court. Since 2012, Professor Blackman has taught at South Texas College of Law, where he holds the Centennial Chair of Constitutional Law. He is also an adjunct scholar at the Cato Institute. Professor Blackman has authored 3 books. His latest, An Introduction to Constitutional Law, is a top 5 bestseller on Amazon. He has also written more than 6 law review articles that have been cited nearly 1,000 times. Professor Blackman is the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy.
Should all play.
He also blogs at the Volokh Conspiracy and actively tweets or X's at Josh M. Blackman.
But not in Brazil.
There will be time at the end of the presentation for questions and answers, so be thinking of questions for our speakers, but please join me in welcoming our esteemed guests.
Thank you so much. Really, he's the big attention. I'm not sure why I'm going first, but I will lead off. The Supreme Court is in something of a state of transition. To briefly recap, the court was very static for many years. Between the mid-90s and around 2005 or so, the court stayed the same. Justice Breyer was a junior justice for about a decade. But things sort of started shifting quickly. Justice O'Connor announced retirement in 2005. Shortly thereafter, Chief Justice Rehnquist died. So then we had John Roberts replace Chief Justice Rehnquist, and we had Sam Alito replace Justice O'Connor. The court then stayed steady for a couple years, but then when President Obama came to office, you had 2 Republican appointees, David Souter and John Paul Stevens promptly stepped down. Souter was replaced by Justice Sotomayor, and Kagan replaced Justice Stevens. Again, we had stasis for about 6 or 7 years until 2016, when Justice Scalia died. As we all know, President Obama nominated one Merrick Garland for the seat. He never got a hearing. President Trump won the election. People were surprised by that, but he won the election. And one of his first acts was to nominate Neil Gorsuch to fill the Scalia seat. About a year later, Justice Kennedy announced his retirement, and he was replaced by Justice Brett Kavanaugh, who had actually clerked for Kennedy. Coincidence? Maybe. But then the court was sort of steady for about a year and a half. In September of 2020, Justice Ginsburg passed away. I wouldn't say unexpectedly. She'd been sick for many years, but she passed away suddenly. President Trump then appointed and confirmed Justice Barrett to fill the Ginsburg seat in the span of about a month. She took office shortly before the election. Okay? And this created what was, at least on paper, the most conservative Supreme Court since the New Deal, back to the 1930s, at least on paper, as I'll explain. Not all the court's 3 conservatives are the same sort of jurisprudential background, but they did push the court very much to the right from where it was. In 2022, Justice Ketanji Brown Jackson replaced Justice Stephen Breyer, and that is the court we have now. I don't expect any more vacancies this year unless something unexpected happens. If Trump wins, you might see Alito or Thomas step down. I'm actually skeptical of that. If Biden, not Biden anymore, if Harris wins, I would expect probably Sotomayor to step down, and maybe Kagan, maybe not. She's a little bit younger. But the court, as it is now, is set. And at least for the next generation or so, we'll have the sort of 6-3 conservative majority. But I've actually spoken about this issue. I'm not so sure that 6-3 is the right count. The way I sort of look at it is what I call a 3-3-3 court. So you have the court's 3 progressives, Justices Sotomayor, Kagan, and Jackson. And they vote together nearly in lockstep. They very rarely disagree. Sometimes they do, but they're usually together as a block. And when they vote apart, it doesn't actually make a difference in a case. So, it's a free vote, as they say. And then you have the court's 3 most conservative members. You have Justice Clarence Thomas, Samuel Alito, and mostly Neil Gorsuch. They're usually together in cases. They vote together at a high rate. Gorsuch has some issues where he sort of leaves a reservation, so to speak, including Indian law, as well as cases involving, a couple of you got that one, as well as cases involving LGBT rights. We'll see what he does this year with Scrimeti, a case involving Title IX. But then really the center of the court is what I call the middle 3. You have Chief Justice John Roberts, for whom Stephen clerked for. You have Justice Brett Kavanaugh and Justice Amy Coney Barrett. Now, I'll be very clear. These are all conservative jurists. I don't want to pretend they're not. They come from very conservative backgrounds, and these are not, David Souter or Sandra Day O'Connor or Anthony Kennedy. I put that out there. But they have different sort of approaches to the law. John Roberts cares deeply, I think Steve would agree with me, on what the court, or how the court's perceived as an institution. This matters to him. I think he views the role of the court as to be one that doesn't step too far to blind. His decisions in the Obamacare case and others demonstrate that he's able to put sort of this institutionalism even above what he might think is probably the better reading of the law. Justice Kavanaugh has some shades of Roberts in him, but not quite as much. I think Kavanaugh has a much stronger concern about the administrative state and separation of powers. He's very vigorous in these issues. And also, I think he's a good social conservative, but he too does have concerns about how he's perceived, how the court's perceived. I think that does sort of play into it. Then we have the most curious member of the court, Justice Barrett. And actually, of all the members, she's one that you all can relate to because you are law students and law professors, right? So imagine you raise your hand in class, say, Professor, I have an idea. And the professor says, that's nice, where's your theory? You've heard this one, right? Right? You have an idea, it's like, have you really thought this through? Where does this lead? What are the consequences of your opinion? Basically, Socratic method 101. She's taken that same approach to the U.S. Supreme Court, which as a law professor, I get. But as a student of the court, it's horrifying because I know how law professors sort of behave, right? Law professors never actually come to conclusions. They sort of always very hesitant, very cautious, very tentative. Like, well, I don't know, let's have another symposium or something, right? Let's do a law review conference on this. And that's really Barrett's MO. I think she's an originalist. She's a textualist. She cares deeply about the law, but she requires so much to get herself going and actually do something that in more cases than not, she just upholds the status quo and she sort of rejects what might be an otherwise good originalist answer. She wants you to persuade her and give her a theory. She's been very clear about this. Her decision in the Burkine case a couple of years ago involving the Indian Child Welfare Act very clearly makes this point. She wants a theory of everything. You will be lawyers soon. You'll be very good lawyers. You cannot give a theory of everything. It doesn't exist. And when you can't get that theory, the government wins. So let's talk about a couple big cases. I took 3. Stephen has a couple as well. Let's start with guns. Zaki Rahimi, not a good dude. You do not want this guy at your birthday party, right? He goes to Whataburger. He shoots people. He sees his girlfriend. He shoots people. He's shooting people all the time. Doesn't hit them. Did he actually hit anyone? I don't know. He shot so many people, didn't hit anyone. Anyway, he kept shooting people. Eventually, his girlfriend got what's called a domestic violence restraining order. He lives in Tarrant County, if memory serves. He got this domestic violence restraining order. It's not a conviction, but it's basically an order from a judge saying, stay away from this person. But there's a consequence of having a DVRO. Under federal law, you become a disqualified person. Under Section 922G, you cannot have a firearm. Of course, he had a firearm. He started shooting people again. He was indicted and convicted and so on. But while his litigation was pending, the court decided the Bruen case. Bruen held that there's a right to bear arms outside the home. And Bruen adopted this sort of historical approach to the Second Amendment, that we have to look to a history to find analogies between a present-day gun control law and some gun control law that existed long in the past. Okay? My beloved Fifth Circuit said, aha, there's no history and tradition for having these domestic violence restraining orders, right? If you were convicted, you lost your gun rights, but you can't take away your gun rights just because you're accused of a crime or threatening someone. That's not enough. The case goes to the Supreme Court, and it's not going well for Mr. Rahimi. The justices were all over him. The vote ultimately was an 8-1 decision. Fifth Circuit was reversed. Justice Thomas was in dissent. Now, Thomas had written the majority opinion in Bruen, and Thomas explained that, look, there is no history. There's no analogy of taking gun rights away from someone merely because they're dangerous, right? But Chief Justice Roberts wrote the majority, says, there is, right? So what are the examples? Something called a surety law. You know what a bond is, right? The law went like this. If someone posed a threat to someone else, a magistrate might say, you must post bond and have people support you, like a character reference. And we will hold this money. And if you go ahead and do something dangerous, you surrender the bond. Okay, that's number one. The second type of laws were felon disenfranchisement, where if you were a felon, you cannot own a gun. And what Roberts did was he glommed them two together. He said, okay, there was support for having some restriction before you committed a crime, and there's support for taking gun away after you commit a crime. So let's just merge these two things together. Let's glom them together and make this new tradition. Roberts says it's close enough. The law, he says, is not frozen in amber. Thomas says, no, you can't do that. You have to look for an analogy, and you can't just make up laws that never actually existed. But Thomas is all by himself, right? All by himself, just won, 8-1 vote, and it was reversal of the Fifth Circuit. So as far as I'm concerned, Bruen has been sort of quietly walked back. They didn't overrule Bruen, but they sort of walked it back a bit. And I went with the John Roberts version of the Second Amendment. And that's probably where we'll be for a while. The court will not grant any other cases unless the Fifth Circuit gives them something else to reverse. Speaking of the Fifth Circuit, let's talk about social media. There were two social media cases in the docket, both arising from my beloved Fifth Circuit, sensing a pattern for this term. The first is called Net Choice. There were two cases, one from Florida, one from Texas. Net Choice is this consortium of various social media companies like Twitter, X, and Facebook, and Instagram, and so on. Texas and Florida enacted laws that regulated social media companies. They required that they provide justifications if they sort of take down content. They can't so-called shadow ban people, and these various other regulations. The 11th Circuit said this is unconstitutional. Fifth Circuit said, no, this is fine. This is like regulating a public utility, and these social media companies are no different than the power company or the phone company of the old days. Goes to the Supreme Court. The court does some weird stuff, and I don't want to say weird that it's confusing, but something happened here, and I'll just tell you what I think happened. Initially, when this was litigated, it was brought as a facial challenge. What's a facial challenge? They challenged the law on its face. That is, it's never gone into effect, and they didn't even argue how it applies to them. They just said this law is unconstitutional at large altogether. But usually in litigation, you might bring what's called an as-applied challenge. It is, this law harms me in X, Y, and Z way. Issue an order so you can't do X, Y, and Z. So all 9 members of the Supreme Court seem to agree that the as-applied challenge was the right way to go. And so they sent it back down to the lower court. But beyond that, it was kind of strange. Justice Alito wrote an opinion for a couple of justices saying, you know, we're going to send this back down, but this public utility thing has some merit, right? The state does have some leeway to regulate these large concentrations of power. And then Justice Kagan had this opinion where she sort of said, no, we need a robust First Amendment. We can't censor the speech of these social media companies. And then Justice Barrett had this sort of very strange concurrence. She didn't have a theory for this one, where she said, well, let's think about, you know, algorithms and AI and all the things that weren't presented. By the way, Barrett is just not consistent. She will go off on tangents when it's something interesting to her, right? So whatever. You know, tell me about your theory of AI, Justice Barrett, right? What happened here, I think, and it's been confirmed by reporting, is that Alito lost the majority. Barrett originally signed on to Alito, and at some point she got spooked, said, never mind. And then Kagan was like, come here, my precious, right? Come to me. And then Kagan joined the Barrett, Barrett joined the Kagan opinion. But it was a very strange split. The other social media case involves something called jaw boning. You ever heard this experience? Jaw, it's a weird phrase. I don't know what it means, jaw boning. But this is when a government official calls you and says, hey, I saw this story you wrote. I don't like it very much. Maybe you should think about something else to write about. And of course, you're not obligated to take it down, but I write all these laws and enforce laws. You know, it'd be a good idea if you take stuff down. You're kind of like if a horse head winds up in your mattress in the morning, right? You know what that means, right? You don't have to figure out the details. And so, as you probably know, we had a pandemic. You may have forgot about. We had a pandemic for a couple of years. We didn't leave our houses apparently, and there were things called vaccines, which I don't know how effective they are. Who the hell knows anymore? But at the time, Facebook said you cannot post anything that is even remotely skeptical of vaccines. God forbid, right? And, you can't say anything about the origin of COVID. Don't even say the word China. That's racist, right? It turns out that people in the government may have had some contacts with social media companies urging, saying, you have to take down this disinformation. That's the phrase, disinformation. There was no government order saying you have to take it down, but they said, it'd be a good idea if you do. And I'm the Surgeon General, and, I'm an important person. Louisiana, Missouri, and some other jurisdictions, parties brought lawsuits in district court in Louisiana saying that this violates their First Amendment rights. That the government, not just Facebook, but the government leaned on social media companies to censor their speech. And this case goes to the Supreme Court. And again, you don't get a ruling on the merits. This is another Justice Barrett special. It's a ruling on standing. And she was a Fed court professor. She will tell you that. And she is a stickler for standing. Same for California v. Texas, another Obamacare case from Fifth Circuit. Justice Barrett found that despite how many thousands of pages of the record, many things, it was a 40,000-page record, that there was no actual standing, that no one had any injury anywhere. And it was meticulous. She went through every single allegation. No, this is not enough. That's not enough. That's too attenuated. No. It's just, I've never seen an opinion like this where a judge goes out of her way to kill every possible theory of standing. It's comprehensive. Incomprehensible, perhaps, but it's comprehensive. So as a result, no one had standing, and this went on. There was a dissent, again, by the three conservatives, Alito, Thomas, and Gorsuch, saying, come on. In any other case, you would never be this strict on standing. You just don't want to decide this case. And Alito made this point before that Barrett is kind of lacking courage. And she just doesn't want to decide the case, so she goes out of her way to kill it on standing. This is a common theme on the current court, where Alito calls Kavanaugh and Barrett basically cowards. I have a new paper called Judicial Courage coming out eventually in the Texas A&M Journal, and I think it speaks to some of these issues. The last case I'll talk about involves, again, Trump. Everything's Trump, I suppose. Involves insurrection. Do you remember this? This was a really big thing 7 months ago that no one cares about anymore. So January 6th happened. We all remember what happened. There's a guy with the Viking hat, right? Remember that? At the Ellipse near the White House, President Trump gave a speech. He said, fight like hell, go march, but be peaceful. People marched to the Capitol, some peacefully, some not. And people broke into the Capitol. They stormed the building. They demolished windows. They sat on Nancy Pelosi's desk. They stole laptops. They did lots of bad stuff. In the wake of J6, many people were charged with various crimes, property, trespass, assaulting an officer, and so on. But no one was actually charged with insurrection, trying to overthrow the government, basically. There were no charges. The Proud Boys were charged with seditious conspiracy, which is different than insurrection. Differences are not important now. Trump was never actually indicted for insurrection. So everything Jack Smith did, and Steve will talk about Jack Smith in a bit, Trump was never charged with insurrection. But private citizens said, we will do this. And there was a nationwide campaign to bring lawsuits against Trump for violating Section 3 of the 14th Amendment. Now, how many of you studied Section 3 of the 14th Amendment ever? Or ever heard of it before last year? Never. Section 3 was enacted in the wake of the Civil War, and it said certain people who held government office and engaged in insurrection can't hold certain government offices. This was designed to keep Confederates out of government, right? That was the purpose of this provision. But they said, aha, January 6th was an insurrection, Trump engaged in an insurrection, and that he must be disqualified from being president. Just to be very clear, the argument. In order to save democracy, we have to take a candidate off the ballot. Right? To save democracy, we'll tell you, you can't vote for the candidate of your choice. That's how democracy works. Just be clear. When my colleague Seth Barrett-Tillman and I had written about this issue before, and we realized on January 7th, we said, uh-oh, they're going to go after him in insurrection. We started writing an article on January 7th because we knew this was coming down the pike. It went in a number of courts. Most courts said, no, go away. This is a political question doctrine. This is not for us to decide. The states can't do this, and so on. But the Colorado Supreme Court, in their infinite wisdom, ruled that yes, to save democracy, Trump must be kicked off the ballot, and they ruled him off. The case went to the U.S. Supreme Court. I filed amicus briefs. I did lots of work in this case. But the upshot the court held is that the states cannot remove a candidate from the presidential ballot. That's a role for Congress. The court sort of leaves open whether Congress does that by statute or they can do it at the joint session of Congress. That will become important in a few months. But they say, Colorado, go away, leave us alone, and this issue's fallen apart. Justice Jackson, Sotomayor, and Kagan dissented. They said that, no, well, we agree. We agree you can't kick Trump off the ballot, but you said too much. Don't say anything about what Congress can or can't do. And then Justice Barrett had this weird concurrence, not very theoretical, where she said, the dissent is very strident and they use very harsh language, but the majority also went too far. So I don't even know what that concurrence means to this day. I'm not entirely sure. But the upshot is Colorado could not kick Trump off the ballot, but just you wait, as Hamilton would say. On January 6th of 2025, we'll have a joint session of Congress. Let's say Trump wins the Electoral College, but the Democrats control the Congress. Is that possible? Will we see members of the Democratic Party object to Trump's votes on the ground he's an insurrectionist? Will they disqualify him on the floor? Basically what Mike Pence was told to do, Vice President Harris could do, right? Kamala Harris will preside over the joint session unless Biden resigns to make her president for a couple months, right? It could happen. So basically, Kamala Harris might gavel out Trump as the winner. We'll see what happens. It'll be wild. But the court's decision not to resolve insurrection was very significant. All right, I'm done. Stephen, bring us some sanity, please.
All right, exciting stuff, but it's going to get more exciting, so we're going to talk about admin law.
Oh, man. Oh, man.
Thank you, Professor Blackman. Thank you to the Federal Society and everyone for being here today. I'm going to jump right in with one of the hottest cases of last term, Loper Bright, which put an end to the doctrine of Chevron deference. So bear with me for the setup here because this is an admin law case, but this case involves a statute called the Magnuson-Stevens Fishery Conservation and Management Act, which created regional fishery management councils. Those councils developed fishery management plans, which are then promulgated as regulations by the National Marine Fisheries Service. So the statute here says that fishery management plans can require ships to carry observers on board, essentially to make sure that these ship captains are complying with the regulations. But it doesn't address specifically whether Atlantic herring fishermen may be required to bear the costs of the observers. So the New England Fishery Management Council requires Atlantic herring fishermen to carry these observers and pay for them, which cuts into their profits by 20%. The fishing businesses then challenge the rule as inconsistent with the statute. The district court rules for the government. It concludes that the statute authorized the rule, but even if the statute were ambiguous about that, deference to the agency's interpretation was warranted under Chevron. So what is Chevron deference? Since 1984, Chevron deference has been the court's answer to how to resolve whether a regulation adopted by an agency, is consistent with the statute passed by Congress. And Chevron famously poses a two-part test. The first, at step one, courts ask, has Congress directly spoken to the question at issue? If so, then that's the end of the analysis. But at step two, if the statute is ambiguous, then the court asks whether the agency has offered a permissible or reasonable construction of the statute. And if so, the court then defers to the agency's interpretation of the statute, essentially giving the agency's regulation the force of law in interpreting the statute. So the DC Circuit then affirms the district court here, concluding that it was, quote, not wholly unambiguous whether the statute allowed the agency to compel the fishermen to pay for observers. And because there was, quote, some question as to Congress's intent, the court proceeded to Chevron's second step and deferred to the agency's interpretation as a reasonable construction of the statute. This goes up to the Supreme Court, which then reverses in an opinion by Chief Justice Roberts for the 6 conservatives, which overrules Chevron. So the court here paints Chevron as a departure from the traditional judicial function, which is, as Chief Justice Marshall put it in Marbury versus Madison, to say what the law is. The Administrative Procedure Act, which is kind of the text of administrative law, was adopted in 1946, and it codified that traditional understanding by specifying that courts, not agencies, decide all relevant questions of law that arise on review of agency action. That text, the court here says, means what it says and requires no deference to agency regulations interpreting statutes. Chevron, the original decision in 1984, never even addressed the APA, and the court says that it defies the APA's clear command that courts need to exercise their independent judgment in resolving questions of law. Because Chevron had been a precedent of the court for 40 years, the court then undertakes a stare decisis analysis. Recall that stare decisis is at its zenith in interpretation of statutes. But the court here holds that all the traditional stare decisis factors cut against maintaining Chevron. The court says Chevron was fundamentally misguided from the start and has prompted the court to create a host of exceptions over the intervening decades to hem it in. The court says it was also unworkable because courts don't agree about what ambiguity means in interpretation of the statutes. And the court also says that it is not a stable background rule that's fostered reliance. In fact, the court says Chevron has destroyed reliance because what Chevron does is it means when administrations change over, a new presidential administration can come and adopt a different interpretation of the statute that can reverse the meaning of that statute 180 degrees. That's known as the Brand X problem in administrative law. The court says here, it makes clear that it's not calling into question all prior cases that relied on Chevron. The court says the holding of those cases that specific agency actions were lawful are still subject to statutory stare decisis, so it's limiting somewhat the disruptive effects of its decision. Justice Thomas writes a concurrence. He agrees with the court that this is inconsistent with the Administrative Procedure Act, but he also says it's unconstitutional. He says that Chevron violates the Constitution's separation of powers by curbing courts' exercise of the judicial power under Article 3 and expanding agencies' executive power under Article 2. And that's significant because it means that Congress can't come back and reinstitute. If that were the law, which is just a concurrence, but if it were the law, it would mean that Congress couldn't come back and reinstitute Chevron through statute. Justice Kagan writes a forceful dissent, joined by Justices Sotomayor and Jackson, and she frames the question this way. When Congress's instructions have run out, who should give content to the statute? A court or the expert agency Congress is charged with administering the statute? To Justice Kagan, Congress correctly said it should be the agency because Congress would prefer expert agencies to make the call on how a statute should be read. She faults the majority from departing from judicial humility and adopting a rule of what she calls judicial hubris, in which judges have exclusive power over every complex issue involving the meaning of regulatory law. Now, Justice Kagan cut her teeth as an administrative law scholar at the University of Chicago and then at Harvard Law School. And her opinion is at its best here when it gives concrete examples of tricky statutory interpretation questions in Chevron's domain. So, for example, she asks, when does an alpha amino acid polymer qualify as a protein? Anybody want to guess the answer to that question? I don't know either. Or when is one squirrel population distinct from another for purposes of the Endangered Species Act? Again, that's a pretty tough question. So she's posing these questions here to give intuitive appeal to her position that we would really want the scientists and the experts in the agencies to answer those kind of discrete technical questions rather than courts and judges who are generalists. That's a pretty effective point, but I think the weakest part of her opinion is her inability to address the majority's point that when an agency isn't involved, courts are often required to confront and resolve ambiguities in the meaning of statutes and have no hesitation in doing so. So why should the entire approach of courts change just because an agency is involved in the case? She has no answer to that question. Justice Kagan ends her dissent by admonishing the court that, quote, judges are not experts in the field. But the Chief Justice has a good retort to that, as he often does. He says, that depends, of course, on what the field is. If it is legal interpretation, that has been emphatically the province and duty of the judicial department for at least 221 years. Pretty good. Okay,
He's a good writer.
So a couple of observations about this one. If you've been following the court recently, you could put this up there with Students for Fair Admissions from last term as a major decision that's been a long time in the making for the conservative legal movement. I also think this decision reveals just how much the court has changed in the last 5 years, as Professor Blackman spoke about. So 5 years ago in Kaiser versus Wilkie, the court considered the related question of whether to overrule the doctrine of our deference. Our deference requires courts to defer to agencies' interpretation of their own regulations, so long as those interpretations are reasonable. And the court took up the question of whether to overrule our, but it ended up backing away from the ledge. It kind of tightened the doctrine up, but declined to overrule it. Now, 5 years later, the court has proved itself willing to take the bigger step and overrule decisively Chevron. So that just shows how much the court has changed recently. The second observation on this is Chevron is dead, but what about Skidmore? So-called Skidmore deference, which might be better called Skidmore respect, is a principle that gives persuasive but non-controlling weight to agency interpretations according to their cogency and coherence. It's hard to tell now just how consequential Loper Bright will be on the ground. The million-dollar question is how much the more pragmatic justices like Justice Kagan on the lower courts will lean on Skidmore deference to continue to give this deference to agency interpretations despite the overruling of Chevron. Justice Kagan warned about this possibility in her dissent in Loper Bright and has also talked about it at the Ninth Circuit Judicial Conference, so that's something to keep an eye on how consequential this change in the doctrine will actually be. Okay, the next big case I'd like to talk about is a fun one called City of Grants Pass versus Johnson. In this case presents the question whether the enforcement of laws regulating camping on public property constitute cruel and unusual punishment that is prohibited by the Eighth Amendment. So the background of this case is that our country has been experiencing a wave of homelessness, and homeless populations have exploded in major urban areas across the country, and in particular in Western states. To meet that challenge, some cities, including Grants Pass, Oregon, who's the petitioner here, paired shelters and treatment programs with the enforcement of laws that restrict camping in public places like parks, streets, and sidewalks. 2 homeless people in the city violated those public camping laws. They challenged them as violating the Eighth Amendment's prohibition on cruel and unusual punishments. The district court agreed and enjoined the city from enforcing those public camping laws. In doing so, the district court was applying an earlier Ninth Circuit decision called Martin versus Boise, which held that a similar public camping law violated the Eighth Amendment when it was enforced against individuals who lacked access to alternative shelter. So the idea here is that when shelter is unavailable, punishing people for public camping amounts to punishing them for their status of being homeless rather than any action they're taking. So their action is kind of involuntary. They can't find a home. There's no shelters available for them. So you're really punishing them for their status as being homeless. The Ninth Circuit affirms the district court's injunction and holds that all homeless people in Grants Pass, Oregon qualify as involuntarily homeless because there are no available shelters. The Ninth Circuit then denies rehearing en banc over the objections of no fewer than 17 judges. There are a lot of judges in the Ninth Circuit. Grants Pass then seeks certiorari from the Supreme Court, and it's joined by a large number of states, cities, and counties, including some kind of unlikely fellow travelers such as Los Angeles, Portland, San Francisco, and California, who all come as amici urging the court to grant review, basically saying how disruptive this Ninth Circuit rule has been to their ability to govern their own states and localities. The Supreme Court, in an opinion by Justice Gorsuch for the 6 conservatives, reverses. Now, as good originalists, your first question about this case might be, what does all of this have to do with the Eighth Amendment? The Eighth Amendment is about the types of punishments the government can impose after securing a conviction, not about the types of behaviors the government can criminalize, right? It doesn't say you can't punish X, Y, or Z. It says no cruel or unusual punishments can be inflicted. And that's exactly where the court lands at the end of this opinion. This just isn't an Eighth Amendment issue. It might implicate other constitutional provisions, might implicate the Due Process Clause, but it doesn't have anything to do with the Eighth Amendment. So what's the other side of the story, and how did this get all the way to the Supreme Court? Well, the challengers here relied on a 1962 decision called Robinson versus California. And in that case, the court had held that the Eighth Amendment prohibited California from enforcing a law that made the status of narcotic addiction a criminal offense. So the law said just that, it's a crime to be addicted to narcotics. And the court says, no, that's an Eighth Amendment violation because this is a status-based crime, it's not an action-based crime. The court in today's decision cast doubt on Robinson's status as good law, says might have been wrongly decided even from the beginning, but it says it has no need to weigh on that here because the public camping ordinances are not like the law at issue in Robinson. These statutes don't say it's a crime to be homeless. They talk about the actions you can't take in a public place, and so it's clearly an action-based and not a status-based crime. The court adds that it's already rejected the argument that the Eighth Amendment prohibits the punishment of actions that defendants can't help but undertake. So in a case called Powell versus Texas that was written by the arch-conservative Thurgood Marshall, he wasn't conservative, the court rejected a challenge brought by an alcoholic to a statute making it a crime to be drunk in any public place. So this person made essentially the same argument. They said the statute says you can't be drunk in a public place, but I'm an alcoholic. I can't help but be drunk wherever I go and in public places. And so this is a status-based crime. Thurgood Marshall says that's ridiculous. This would eliminate all sorts. This would be kind of a limitless proposition that would wreak havoc on the criminal law. The state retains the authority to punish an act that society has an interest in preventing, even if that act could be described as involuntary or occasioned by a particular status. So here the court says that fits this case exactly. Even if public camping is occasioned by the status of being homeless, it doesn't mean the government is powerless to do anything about it. Justice Sotomayor dissents. She's joined by Justices Kagan and Jackson. This is a passionate dissent. Justice Sotomayor feels very strongly about this issue. In her view, the case calls for a straightforward application of Robinson, and because she thinks the ordinances effectively criminalize the status of being homeless, they run afoul of Robinson's rule. She says the majority is really adopting a formalistic and empty distinction. To her, there's no difference between criminalizing the status of being homeless and criminalizing the conduct that defines that status, namely camping in a public place. So observations on this case, I would say in the field of constitutional interpretation, there are a lot of hard questions for originalists. I don't know if Professor Blackman would agree with me on that. But this is not one of those cases.
Nope.
Okay, the Eighth Amendment prohibits cruel and unusual punishments. It doesn't have anything to do with what conduct can or cannot be criminalized. This case is a good example of how a straightforward understanding of original meaning of a constitutional provision like this one can make short work out of an area of law that's gotten twisted around the axle.
Oh, I like that. Twist around the axle. That's a good phrase. I like that.
For you. All right, the third case for today, and the last one I'll talk about, is the court's grand finale, Trump versus the United States. In this case, considered whether a president can be criminally prosecuted for his official acts. The case involved the indictment of former President Trump for conduct that occurred during his presidency after the 2020 election, some of which Professor Blackman has already spoken about. The indictment brought by Jack Smith alleges that after losing the election, President Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results, including through communications with state legislators, coordination with the Department of Justice, attempted persuasion of the vice president, and addressing a crowd of supporters on the morning of January 6th. So based on this alleged conduct, the indictment charged former President Trump with various forms of conspiracy. Former President Trump moved to dismiss the indictment based on presidential immunity, and he argued that all of the indictment's allegations fell within the core of his official duties, so he should be immune from prosecution for them. The district court denied the motion, and the DC Circuit affirmed. It held that a former president may be criminally prosecuted for even his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the Congress's law. So because you're prosecuted means that you could have been prosecuted, essentially, following the reasoning there. And therefore, the president acted outside of his lawful discretion. So having concluded the prosecution was permissible for a president's official acts, the DC Circuit then declines to decide whether the actions alleged in the indictment were official or unofficial acts. It has no need to make that distinction. This goes up to the Supreme Court, which reverses in an opinion by the Chief Justice, joined in full by Justices Thomas Alito, Gorsuch, and Kavanaugh, and joined in part by Justice Barrett. The majority, it leaves a lot of open questions in this case. This is a massive case of massive importance, and it's a first impression in many respects. So the court doesn't tie a bow on every aspect of the case, but what it adopts is kind of a three-layer approach to answering these questions. So the first layer, the court talks about official acts that are within the president's exclusive authority. And here the court says the president has absolute immunity from prosecution. So these are acts within the exclusive constitutional authority of the president that courts have no power to control. So for example, the president's exercise of the pardon power. The Constitution gives, Article 2 of the Constitution gives this power exclusively to the president. So Congress can't criminalize an exercise of the pardon power, and a court can't sit in judgment over a criminal charge based on such an exercise, because both would interfere with the president's exclusive authority over that area. So that's the easy one. That's layer one, set that aside. Okay, layer two, more difficult. Official acts that are outside of the president's exclusive authority. So they're official, but they're not within that narrow slice of things that the Constitution textually commits to the president alone. Here the court says the president has at least presumptive immunity. It's not going to decide whether it's just presumptive or absolute at this point, but it's at least presumptive immunity. So much of a president's power is not exclusive. It's not these things like the pardon power that are committed to the president alone. Sometimes he acts pursuant to an express or implied authorization of Congress, so a statute that Congress passed that empowers the president, or sometimes it's an area of concurrent authority that he shares with Congress. In this area, the court says he gets at least a presumption of immunity. The key precedent here is a case called Nixon versus Fitzgerald, in which the Supreme Court held that the president is immune from civil damages liability, so it's considering civil liability, not criminal, for his official acts, because otherwise the threat of those suits would divert him from his duties. So if he had to pay attention to being sued by people all over the country all the time in civil suits based on his official conduct, it would divert him from doing what needs to be done in the exercise of the executive power. The court here reasons that the danger of criminal prosecution to the executive function is greater than the threat posed by civil suits. The fear of imprisonment and public opprobrium that come from a criminal prosecution are more likely to distort presidential decision-making. So if the president needs to make a hard decision, whether to use military force or something else, we don't want him in the back of his mind thinking, am I going to be prosecuted and put in jail for this after my term in office ends? At the same time, the court considers a countervailing interest in fair and effective law enforcement. And taking the competing considerations into account, the court concludes that the separation of powers necessitates at least a presumptive immunity from criminal prosecution for a president's official acts. So what does that mean? It means the president is immune from prosecution for an official act, at least unless the government can show that applying a criminal prohibition to that act would pose no danger of intrusion on the authority and functions of the executive branch. So the court kind of leaves an open question about how the government is going to make that showing. The third layer here is unofficial acts, and that's quite simple. The court says no immunity. So prosecuting the president for his unofficial acts poses no separation of powers risks at all, because by definition, it doesn't implicate a president's presidential responsibilities. So that's simple. The court then takes these new principles and it applies them to some of the allegations that are alleged in the indictment. It holds that some of the allegations involving President Trump's discussions with the acting attorney general were plainly official and involved exclusive presidential authority, so communications with his own executive officials, absolute immunity. It then holds that President Trump's discussion with Vice President Pence were official, but non-exclusive, and therefore President Trump was at least presumptively immune from prosecution for that conduct, but perhaps the government can rebut it on remand. And as for the remaining conduct, the court declines to classify it. The court also holds that if the president is entitled to immunity for certain official acts, the jury can't consider evidence of the president's official acts to prove liability on any charge, and that might prove very important in the way that everything plays out on remand. Justice Thomas concurs. He argues that the Attorney General's appointment of Jack Smith as a special counsel violates the appointments clause because no statute authorized the creation of his office. This argument was quickly picked up on by Judge Cannon in the Trump Presidential Records Act prosecution, who then went to dismiss the indictment. Professor Blackman can tell you why.
Yes, I can.
Justice Barrett concurs in part, again showing her independent streak that we've been talking about today. She doesn't join that part of the court's opinion I mentioned about whether the Constitution limits the introduction of protected conduct as evidence in a criminal prosecution of a president. Then Justice Sotomayor dissents. She's joined by Justices Kagan and Jackson, and she really turns this dissent up to an 11. She accuses the majority of just making its rule up and ignoring constitutional text, history, and precedent. For example, she says if presidents are immune for their official acts, why did Gerald Ford feel the need to pardon President Richard Nixon, and why did Nixon feel the need to accept it? As for the Fitzgerald case I mentioned, she thinks the threat of criminal liability is much smaller than civil damages, and that we should be less concerned because criminal prosecutions require robust procedural safeguards. She ends her dissent with a parade of horribles for the history books. Orders the Navy SEAL Team 6 to assassinate a political rival. Immune. Organize a military coup to hold on to power. Immune. Takes a bribe in exchange for a pardon. Immune. 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 I didn't make that up. That's it. With fear for our democracy, she concludes, I dissent. Okay, this is heady stuff. So observations about this. This is an opinion for the ages, as I said. The court makes this explicit throughout. The court is really, I think, not fixated on the facts of this particular case. It's making a rule that's going to affect presidential administrations in perpetuity for the future of our country. And I think the court has its eyes on the long term here. So the Chief Justice writes, this case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. So the court is quite aware that it's writing things for the first time. They're going to have a long tail. The court says, unlike the political branches or the public at large, we cannot afford to fixate exclusively or even primarily on present exigencies. In a case like this one, focusing on transient results may have profound consequences for the separation of powers and for the future of our republic. Our perspective must be more farsighted. Now, like many of the court's key separation of powers cases, like Youngstown, if y'all have read that in constitutional law, this case does not contain a lot of textual analysis, and that might be dissatisfying to textualists or originalists. But the reality is that many of the principles guiding how the branches relate to each other derive from structural reasoning rather than individual provisions of the Constitution. And that's very much the case here, along with a lot of the court's other big separation of power cases. At bottom, the majority of the dissent differ over what we as Americans should fear more. Should we fear a president who feels empowered to violate the criminal law? Or should we fear a tit for tat where each president is free to prosecute his predecessors, yet unable to boldly carry out his duties for fear that he may be next? Only time will tell which of these visions is correct. So that does it for the major cases of October term 2023. We're now looking forward to October term 2024. And while the court hasn't granted a lot of big ticket cases yet, I do have one for you to keep your eyes on. And that case is called Wisconsin Bell versus United States ex rel Heath. This is the case that I'm currently litigating with my colleague Allison Ho, Gibson Dunn. It involves whether reimbursement requests made to the FCC's E-rate program are actionable claims under the False Claims Act. This program subsidizes schools and libraries' purchases of telecommunication services. And it's funded by the payment of telecom carriers like AT&T and Verizon, who pay money to a nonprofit company, which then distributes the money out to the schools and libraries. A relator alleged that AT&T had defrauded this program and should be held liable under the False Claims Act. The False Claims Act only applies when the government provides the money issued. And here the money has been provided by private telecom carriers and is never touched by the government. So our theory of the case is that the False Claims Act, which is always meant to protect the public fist and not private money, doesn't apply to these reimbursement requests. The case is going to be argued on November 4th, so I recommend you tune in and listen to how the argument goes. In conclusion, October term 2023 was another big year at the court. Many of the court's decisions will reverberate across our nation for years to come. Thank you so much for joining us for today's roundup, and we'd both be happy to take any questions that you might have.
Yes. Questions? Yes, ma'am.
Both of you mentioned a little bit about the standing doctrine, and I'm just curious how you think the court's handling of it will impact lower courts and even practitioners and how they think about the types of claims that they're bringing.
Yeah, there's really a red-blue doctrine where blue states have standing, red states don't. I'm only slightly exaggerating, but if you actually look at the last couple of years, Texas loses standing on almost every case, but during the Trump years, blue states had standing to bring all sorts of claims. Standing is one of these areas where the court's been, I think, inconsistent. And Justice Barrett in particular sees herself as a standing stickler. That's what she wants to do. She wants to be the standing justice. And when you have that standing, there are very often theories that are advanced in the lower courts that are modified on appeal. So I'll give you an example. The mifepristone case, another case from the beloved Northern District of Texas. This involved a drug that's going to be used to facilitate abortions. A group of medical professionals brought suit, and their argument was a little bit attenuated. I'll explain it. They said, well, the FDA approved this drug. This drug may lead certain women to have complications from abortions. And those women who seek medical treatment for complications can come to us. So it was a chain of inferences, right? But also there were certain conscience issues where they said, we will be forced to provide these abortions because federal law says we have to do it, and we are morally opposed to abortions. In the district court, the government said that, yes, you have to perform the abortion, your conscience be damned. Clearly, damning your conscience, I suppose. But on appeal, the government said, aha, no, conscience protection. We would never force someone to provide an abortion. And so basically, the cases change as they go from the district court to the Supreme Court. So, Caroline, my answer to your standing question is actually most indirect. Very often, theories of standing are one thing in the trial court, something else in the Court of Appeals, and by the time it gets to the Supreme Court, they rework the case. So it's very hard for plaintiffs ex ante to see what will be the standing argument 3 years down the road from the government. So it's extremely tough, right? Think of the census case, the DACA case. There's so many of these cases where standing theories change along the way that it's very hard for civil rights litigants to even know what's coming up. But I would love for the court to apply a clear rule standing across the board. If Texas doesn't have standing, then California should have standing. I think rules should be applied fairly. That's a principle I believe in fully.
Yeah, I would say this is an area where following the Supreme Court pays as a litigator. You know, even in your day-to-day practice, when you leave here and you're practicing day-to-day, you might not be dealing with Supreme Court issues every day, but you will be dealing with standing and jurisdictional issues in every single case you ever face as a litigator. So paying attention to developments in Article 3 jurisdictional rules will pay dividends for you, because you need to be developing your record properly throughout, because you might have a problem that doesn't get observed until far later in the litigation process. So you should be the one who's staying abreast of these issues, seeing how the court has considered and changed in these doctrines, so that you can plant those seeds in the record that you need.
Look at the social media case. Who are the lawyers in this case? Paul Clement and Scott Keller, brilliant lawyers. Did they really not think of a facial challenge versus as applied? All the smart judges in the lower courts who didn't see this, Andy Oldham, right? Kevin Newsom, two of the biggest Fed courts nerds in the country, they didn't see it. But magically in the Supreme Court, all 9 judges say, oh, this should have been an as-applied challenge. It's like the professor grading your homework, but he wasn't there when you wrote it. it's impossible to litigate when the court changes the game at the end. Yes, ma'am.
There's so many overrulings. I think there's kind of the spirit in our country of, lack of faith in the judiciary. What would you say to people that have that fear or that are like, okay, they're going back on their decisions? How can we still have trust and faith in those decisions?
Stephen can do this one.
Yeah, certainly. So I think, one reason why it pays to be a Supreme Court observer is because there's more than meets the eye to the court of what's going on. I think Professor Blackman touched on that a little bit with the 3-3-3. It's not a 6-3 block that is uniform in every regard. Look at some of the decisions here, like Rahimi, an 8-1 decision that significantly, I think, could be fairly said to have walked back Bruin from just 2 terms ago. This is not a case where the most, far position is always prevailing in every single case. There is definitely a consideration of institutional concerns. There's a consideration of stare decisis. So those don't always grab the headlines, talking about the divisions within and talking about hesitancy or reluctance to go as far as some parties might want. But that's very much present if you're following the court closely.
Mm-hmm. And a related issue, last term, about half the cases were unanimous. 50%, like 47% might be off by 1% or 2%. And of the 6-3 cases, I think there were 11, only half of them were right-left. There are lots of heterodox splits. So again, if you want to see what a right-wing court looks like, look at the Fifth Circuit, right? Where Judge, W appointees like Chief Judge Richmond, Priscilla Owen, Katarina Haynes, and Leslie Southwick, they're basically the moderates in the Fifth Circuit. They're Republican appointees. They vote with the Democrats, with the Republicans. If we didn't, I'll say this point often, if we didn't get Gorsuch, Kavanaugh, and Barrett, let's say we got, I don't know, Willett, Ho, and Oldham, we'd have a different country, period. Yes?
Since Bush v. Gore, seems the Supreme Court or the judiciary in general has a growing role in presidential elections.
Yeah.
This was particularly true in 2020, and it seems like both Republicans and Democrats are now preparing for a similar outcome.
Yeah.
At the end of this year, that is certainly a change in the role of the court, even if it may not be a formal change in its jurisdiction. It definitely is a social one.
Mm-hmm.
I'm curious to hear what you think of it.
I mean, look, so you all were not alive for Bush v. Gore. It's a fact of life. And if you lived through it, it was a very strange period. What people don't remember is that Al Gore had a choice to make. Do you bring this case to the Supreme Court? I mean, he didn't have to, right? It was called Bush v. Gore for a reason. He chose to litigate this case in the courts. Once you bring a case to the courts, they have to do something with it. And this Justice Jackson's made this point. In other words, the justices don't want to have to resolve elections. That's not what they want to do. But when parties have disputes, there has to be some independent branch of government to resolve it. There's no way around it. I mean, I think in the 2020 election, the Supreme Court largely did virtually nothing. The 2020, they said, oh, we're not going to get involved. And they sort of didn't intervene. In fact, Justice Barrett, one of her first acts, I think her first actual vote in the court was to sort of not recuse in 1 or 2 cases when she said, I don't want to do this, right? So I would rather that we resolve elections by votes, but if it goes to the courts, you can't much avoid it. I don't know it's guaranteed that if it's a Trump versus Kamala Harris Supreme Court case that Trump wins because there are 6 conservatives. I hate to say it, I think a couple of members of the conservative bloc would say, see, look at us, we're good, we're going to let Harris win. I don't think that'd be their motivation, but that's how it'll be perceived. And that will get them, at least some, credibility after Dobbs.
Yeah, I think that makes sense. I don't know if you're referring to the Trump versus Pennsylvania case in 2020.
Yeah.
Came out. That was an original jurisdiction case where states were trying to get directly into the Supreme Court without litigating lower, and the court declined to get involved in that case. But sometimes the court can't help but get involved. Like the Trump versus Anderson case would be a great example of that. So you have a state Supreme Court saying the president can't be on the ballot in this case. It kind of threatens a cascading effect. You can see that no one can really resolve the problem. It's created in the judicial system. No one can resolve it except the judicial system. So sometimes the court can't help but get involved in those cases. Who knows how that'll play out in this election?
Yes.
How would Justice Roberts' 3-tier framework in the immunity case handle some of the hypotheticals that Justice Kagan talks about in her dissent about assassinating political rivals or other sort of terrible things that a president theoretically could do?
Yeah, so I guess the first question is whether those fall in the exclusive or the concurrent authority, which raises questions about, with the SEAL Team 6, the war powers and how the president shares, what extent that's exclusively presidential power as opposed to shared with Congress. And there's some kind of difficult common law questions about the extent to which Congress can oversee the president's use of the war powers, the War Powers Act, and other kinds of statutes like that. So that would be kind of the first question. If it falls into the second tier where it's an overlap, then you have a presumption, and then it's on the government to rebut that presumption. But from a litigating perspective, okay, the court says it's a rebuttable presumption. Just go ahead and rebut and show that allowing a prosecution of the president in whatever hypothetical is not going to interfere with his administration. Okay, I don't know. Good luck to the litigators who have to write that brief. Maybe they're doing it right now to explain how or how not this is going to interfere with the president. It's kind of a very empire-y, and it's up and above all the day-to-day facts. So I think we can play out in the brief, and the district court would be making a determination in the first instance about whether this would interfere. Having this type of line, however you want to draw the line on this abuse of power, would prosecuting for that interfere with his administration?
I'll just make a small point on minimalism. This was a debate between the majority and Barrett, where she says, and the dissent, that we shouldn't be thinking about all the other cases. Really, what the court fractured on was things that were not presented, right? I mean, the issue about can you use this in evidence? There's no trial pending. Why are you resolving this issue now? Right? There are no allegations about SEAL Team 6. All that's here was the events of January 6th. So if you want to be really a restrained judge, you would have only decided the issue before you. And the court didn't even do that. So it was a weird case where everyone's saying, you're an activist. No, you're an activist, like the Spider-Man meme pointing at each other, right? But they're all activists, right? They all were doing what they said they weren't supposed to do. It's a very unsatisfying decision. And I think I agree with the bottom line. I think Stephen gave a very careful recitation, but I think this was not the court's best decision, and everyone kind of was accusing everyone else of being a hypocrite.
Yes.
There's been a lot of talk of the Supreme Court focusing on the idea of tradition in deciding a case that is ruined.
Mm-hmm.
How would you say that compares and contrasts with originalism properly understood?
Sure. Right. So there's this troika, this trilogy. You become a three-part test, right? There's text, history, and tradition. Text, I got it. We're looking at a text. There's a constitution. It's in my pocket, right? We all have them. You have one in your pocket? You don't have a constitution in your breast pocket next to your heart? How dare Caroline fix this, okay? Distribute them later, please. So we have text, right? We have history. That is, what happened before the Constitution was ratified that would inform the meaning of that text. That's good. That's originalism. But then there's the third one, which is tradition. And tradition is stuff that comes after the text was ratified. And that creates, I think, a disconnect for originalists. If we're looking at the text and what it meant in 1787 or 1791, why do we care what laws were passed 30, 40 years after ratification? Justice Kavanaugh loves tradition. He wrote this very lengthy concurrence, this homage to tradition, right? In the Bruin-Rahimi case. And he says, well, look, in very often the case, you have traditions, a reflection of what the Constitution means. But also it's kind of like, if you're doing something for a very long time, maybe we should keep on trucking, right? Keep on doing it, so to speak. Don't rock the boat. I think that's a very important part of Kavanaugh's jurisprudence. Barrett, on the other hand here, I think I actually agree with her, saying, why are we looking at stuff that happened 80 years after ratification? Why is that relevant? And I think Barrett has a fair point here. The problem with Barrett, though, is that she wants, again, this 5-volume encyclopedia in every issue of the law that's just not forthcoming. So I think the court's originalists don't all agree. If you want to see an example, Vidal v. Elster, which is an IP case we didn't mention, involved IP stuff, which is not important here, but Thomas and Barrett, when at it head on head, saying, no, you're doing originalism wrong. No, you're doing it wrong. And they don't agree. So even though, again, to Stephen's point, there's a 6-3 majority, they all don't even agree on how to do originalism. So there's going to be fractures in every case. In that case, Kagan and Barrett joined forces, and they wrote this piece that was very critical of originalism, at least the tradition approach that Kavanaugh favors.
Yeah, I think maybe the counterpoint or what Justice Kavanaugh might say about that is if you take away tradition, so the way things have been applied immediately following and right thereafter, you kind of get to a world where it's judges sitting and looking at the text without any consideration of how those things were expected to be applied by the people at the time. And there's kind of been the transition of originalism from original intent to original public meaning, which we've seen over the past several decades. There was kind of a move away from caring about the original expectations. So that's something there's been some disagreement about, and some potential problems. If you do a move away completely from original expectations, you can end up having an interpretation of the law that everyone seemed to agree was not the interpretation of the law, but because we think it's the best reading, it's then adopted as the authoritative original understanding.
You might have one more question?
Yeah, sure. Yes, right there.
Can you talk more about the practical implications of the overturning of Chevron? I've heard a lot of different opinions about what's actually going to happen because of that. Can you speak to that?
No, let the business lawyer do this one.
Yeah, certainly. I think it's probably an open question, which I was trying to refer to at the end, because you have this continuing to exist Skidmore deference doctrine, which says that it's not really a deference doctrine, it's a respect doctrine, but an agency comes in and says, hey, we've always understood this statute to mean X. Okay, we're not gonna have Chevron anymore, which says courts have to defer to that if the statute's ambiguous. But now we can say, well, I'm gonna defer to that because you're the expert, you've been administering this for several decades, and I trust you, and you know the practical implications more. If that happens and lots of lower courts then kind of take that path, you might have something close to the current regime. It just kind of replaces Chevron. We use different language to talk about what we're doing. On the other hand, if judges really take it seriously and then they said, I need to do a pure, clean, de novo review of the meaning of this statute, you can end up having some divergent outcomes where agencies' regs are no longer being followed much less regularly than they were in the Chevron regime. So it's kind of a TBD. We're not totally sure how consequential it's going to be yet.
Well, please help me thank our guests for being here today.
Thank you so much. Thank you, Peter.
We'll see you all September 18th for our admin law event.
Ooh.
Yes, so come back.
Excellent. Thank you. So